It's come to an end of May already. So we are going to start our journey very soon, next June already. Yeah. So after coming through so many series of will and trust talk, and of course, we have to thanks to our speaker, Mr. Chong Mok Young, have been provide a lot of knowledge to us, and ongoing, we have series of knowledge coming out. Yep. And today, what are we going to talk about? Distribution Act. I think a lot of people might not aware what kind of Distribution Act we are talking about. In fact, what we are talking about is Distribution Act of when we are passing, what kind of act that will be implemented to pass our asset to our loved one. So under the Distribution Act, we will want Mr. Chong to explain to everyone who can get about this. If no will written, what will happen to the asset. So Mr. Chong, good afternoon to you. Let's hear from you. What is called Distribution Act? Yep.
Okay. In Malaysia, if a person pass away, I always say there are two routes to move. Either you have a will or you don't have a will. But if you don't have a will, then you have to apply a document called letter of administration. But if you have a will, you have to apply a document called grant of probate. Basically, let me just share with you one slide. This is a slide. You see? This is an important slide that we all of us must know, because for example, if a person pass away without a will, they go through this yellow path. Okay. When you don't have a will, you have to the family member need to appoint a person to be the administrator of the deceased asset. Okay, that guy is called the administrator, and this administrator need to apply a document called letter of administration in order to unlock the frozen asset. Okay, so to apply letter of administration, there are three situations. The first situation is if this disease have only movable asset of less than 600,000, then this person can apply this letter of administration at Amanah Raya. When I say movable asset, means cash, bank, stock, no property, and totality must be less than 600,000. In the case when there is movable asset, there is property, and property and cash in bank all add together is less than 2 million. Then the administrator appointed by the family has to apply this letter of administration at the High Court. No, at the District Court. Sorry, at the District Court, and it must make sure that the total asset must be less than 2 million. However, currently we heard that the latest news that the government is going to increase this level, that threshold, to 5 million, but it's not gazetted yet. It's not approved by the Parliament. Okay, I think the government find that there are a lot of people don't have a will. That's why everybody have to apply letter of administration, and the court also gonna jam. You know, as what I was told, that if you were to apply letter of administration at the local court or the land office, it can take a long time. The queue is very long. Oh, so the third scenario is when the total asset of the disease is more than 2 million. Then the administrator appointed have to go to the High Court. Okay, when we go to the High Court, actually it's not necessarily must be 2 million and above you go to High Court. Even if 60,000 or 50,000 and above you go to High Court to apply, they still require an additional document, additional condition called the guarantor. Not to mistaken that as long as you go to the High Court, they need guarantor. Okay, they need guarantor, but the guarantor can be waived if looking at situation. So normally the administrator will go to the High Court to apply letter of administration when the asset is more than 2 million. So once they get approval from the letter of administration extracted from the High Court or the District Court or Amanah Raya, whatever, then those assets can be taken out. by the administrator. Okay. The administrator, another condition for administrator is he must get consent from all the legal beneficiary. That means who is the legal beneficiary? Normally the parents, the spouse, the children. Okay, this group of people are the legal beneficiary. Once he extracted the letter of administration, the next step the administrator need to do is to apply a document called distribution order. Distribution order. Distribution order is another document whereby you will state who this person left behind. For example, if the mother is there, there's one son, and the husband, then the distribution order will state the distribution that these people will get under the Distribution Act, which we are going to go to. Okay, so the distribution order is another document that the administrator need to apply, and it reflects the distribution order. So after paying all the debts, whatever, you will follow the distribution order. That is Distribution Order, Distribution Act 1958. The Distribution Act 1958 looks something like this. This is the Distribution Act. And you can see in this Distribution Act, if a person die only with spouse, no parents, no children, that means no parents, no children, issue means children, then everything will go to the spouse. And in the case where there's no children, this couple have no children, then the spouse and the parents will get half-half. And in the case there's no spouse, no parents, then all the children will share equally. Okay, so in this situation, when you talk about issue, maybe you talk about say, for example, the uncle had 5 children, but however, one of the children already passed away before he passed long ago. Then in that situation, if that particular child who has a family and has children, then the children will take over the father portion. Okay, so that's why we use the word issue, not children, because if we say children, means stop there already. And if a person is not married, then everything will go to the parents. Okay, when I say everything go to parents, it also include a man. For example, a man not legally married to a wife, but have affair with a wife or staying with a companion. When he pass away, his asset all will go to the parents. Okay, the companion or the partner will get nothing because legally he is not married. So everything will go to the parents, even though he is married, he has a kids, he has a wife, but all these are not legal, what do you call it? Not legal wife, not legal children. So he will be treated as no spouse, no children, all go to parents. And in the case where there's a parent pass away, the children and the spouse will share 1/3, 2/3. And in the case where there's no spouse, parents will get 1/3, 2/3. And this is the more common one where all of us have parents issue. So spouse get 1/4, parents get 1/4, all the children equal share. And however, in the situation where this person is a single, not married, no children, no parents, then legally under the law, the brother and the sister are the legal beneficiary under the law. And if the brother and sister are not able to go and apply LA, or no brother sister, then it definitely go to this elderly relative or uncle. And finally, the government will take over. Okay, so this is the Distribution Act 1958, amended in 1997. Very crucially, we can see here that when you have a house, especially a house, you joint own with a wife, and husband and wife pay the installment. However, at the end of the day, if husband pass away or the wife pass away, it doesn't go to the spouse 50-50. The spouse only get 1/4. So even if no parents also get only 1/3, it's never get half. So the spouse who has been supporting on the housing loan installment, especially, for example, only don't get half of it, only get 1/3. And the priority is still the children. And more issue will start to arise. What happens if the children are all minor? And then in that situation, if this person died without a will, then the administrator need to apply another document called guardianship order, trusteeship order, because there's no trustee appointed. So that's why in a situation where there is minor children and the person passed away without a will, we will not only apply letter of administration, we need to apply the distribution order, we need to apply guardianship order, we also need to apply trusteeship order because there is minor children. So you can see when the person passed away without a will under the Distribution Act, there are 4 documents need to be applied at the court, and it will be much costly. And in the case when there is a will, we just apply a document called grant of probate. At the same time, when you are talking about Distribution Act, the administrator, in order to get the letter of administration, also need to get guarantor if they apply the letter of administration at the High Court. And the High Court require the administrator to provide 2 surety who has the same amount of asset as the deceased. That is why when you're talking about Distribution Act, a lot of people are so scared because it's got a lot of condition attached here, you know, and also will take longer time. And furthermore, when you were to appoint an administrator, the administrator need to get 100% consent from all the legal beneficiaries. And that is also another issue whereby when you have elderly uncle, the children can be everywhere. For example, in London, in UK, how to get consent from them? They are not able to come back, you know. And we see situation where when in the court they need to prove that how many children you have, and all must be there to be confirmed, you know. You cannot say, oh, the husband passed away. Just like I have a case where my neighbor, the uncle is 76, the wife is 74, and when they went to apply a letter of administration at Dewan Bandaraya, the court asked, where is the husband's parents? You know, under Distribution Act, there is a parents there. So my auntie replied to the court saying that I don't even know who is the parents. When I married him, he was already the parent already passed away, and for so many years I never see their parents. And now he passed away. He's 78. Definitely, the parents cannot be located. You know what? The court require the administrator to look for proof to prove that the parents already passed away, because under the law, the distribution order will mention the parents if there is parents. So you say don't have parents, you cannot book D, is what the officer telling the auntie. As you can see here, it's going to be very troublesome when you come to the Distribution Act. Okay, so these are some of the points about Distribution Act. Karen?
Ladies and gentlemen, thinking about not written your will, what are the consequences your family will go through? Especially when we talk about a house, usually financially is actually both husband and wife is actually supporting for the loan, right? Apply for the loan. So if Mr. Husband passed away without writing a will, don't you think that you actually give a lot of trouble to your loved one, especially your wife? Because whatever it is, your portion will not 100% give to her. Yeah, it's not 100% give to your children neither. Okay, this will come by your parents. Again, we have to see the situation of this Mr. Husband. You have how many siblings? Because your sibling is equal to your parents' children. What if the distribution delay? What if this old man, okay, the parents also pass away, okay? And what if the father, end of the day also halfway go through? Then the parents' portion will equally go to who? Sibling, okay? The sibling of Mr. Husband, the A. So in this situation, why should we need to go through all this hassle? Especially when we talk about there are 4 documents that guardianship lah, trusteeship lah, okay? All these consensus that you need to apply. Why can't you write your will? The will is actually very, very crucial, ladies and gentlemen. So if you do have a lot of your friends that have not aware, will writing is very crucial, will affect the harmony of the family. Please don't delay, because the procrastination, end of the day, will create a lot of price. We always say procrastinate, the delay decision, end of the day, you got to pay for it. The cost is very important. So what if there is a will? Okay, how to go about? So Mr. Chong, yeah, just now we have mentioned about no will, the situation that everyone have to go through a process of no will if seriously they have not written any will. But what if this so-called Mr. Customer A have written his will? How exactly he can actually write his will? Okay, what kind of distribution that he can do? Okay, perhaps Mr. Chong, your expertise will come in. Thanks.
Okay, when you write a will, you can decide everything on your own. Firstly, you remember just now we said no will, they need to appoint an administrator, the person to manage your asset. So you can actually, in the will, you appoint an executor, the person you trust, the person you think can manage your asset, fairly and finish the job, okay, from A to Z. Because estate administration is not just to get a court order and then distribute. You have to settle all the debts lah and all those stuff and all legal issue, income tax lah. So you must make sure that this person can be liable. And secondly, also in the will, you can also appoint guardian if you have minor children, less than 21. And you can also do a testamentary trust to extend beyond the statutory trust. That means beyond 18. You can even lengthen the trust above 18 to 25 or 30 or 50. That's called a testamentary trust. And at the same time, you can also appoint trustee that you trust to hold on trust for your estate, instead of let the court decide. Just now we mentioned court trustee act, what they call that, court order for the trustee. Okay, so finally you can distribute your asset according to your wishes. Do not follow the distribution act. Okay, so to have a will is very much advantage. And let me just share the screen again on this one. Okay, so when there is a will, the process, the distance to get to the speed to get the asset transfer is much faster. Because when there is a will, you need to apply a document called grant of probate. And to apply the grant of probate is quite fast because simply the executor naming the will need to present all the document to the court, okay, and do a petition via a lawyer. So once a lawyer put in a petition, the executor will need to appear in court on the hearing date because he need to be confirmed by the court that you are appointed by the deceased. So the court will verify the identity of the executor. And once an executor is been identified, confirmed is the guy, then the court will look at the inventory that have been sent up for the application of the probate and verify, make sure all the documents are there, bank statement are there, car guarantee are there, house guarantee, everything is there, confirmed, correct. Then the court will sign, that is called grant of probate. And with that document, the executor will be able to take out all the asset and settle all the debts, and just now we mentioned that income tax clearance, funeral expenses payment, and medical expenses, other expenses related to this funeral, for example, transfer of body and everything. And once settle all the debts, expenses, then the balance will be distributed according to the will. Normally, for this type of situation, when there is a grant of probate and the will is valid, when I say valid, 100%, not those partial intestacy or half got issue one, the will must be valid 100%. I would say that the process will take the most is about 6 months for a small family. but for a very big empire of an uncle or whatever to be longer. So this is much faster and cheaper compared to going through the letter of administration and the Distribution Act, because that is going to cost you more time, because you see, to find the guarantor is an issue. Many families cannot find guarantor. To get family consent on the appointment of the administrator is another issue that takes time. And finally, to apply for so many documents, letter of administration, distribution order, guardianship order, a trusteeship order, all these need money. So that's why when you have a will, you have a lot of advantage. You can give to whoever you want, the way you want to distribute, and it's much faster and cost effective. That's why, and also the other thing, you decide who is the administrator, who is the executor for your estate, no? And this person that you trust will be able to finish your job. But however, for a situation where I always see that if there is a young minor children, or and you find that you can't really feel comfortable with your family member, or you have no good selection of people, then turn to a trustee company like Rockville to appoint the executor as a corporate executor rather than individual. Because as we mentioned many times before, there are many advantages over to appoint a corporate executor rather than an individual. Because individual is a human. There could be emotion. It can get sick. You know, they are not knowledgeable. They might not have the time to do the job. So sometimes corporate trustee could be a good alternative to be appointed as executor and trustee. Oh, okay, Karen.
Mr. Chang, thank you for your sharing on this. So talking about this, right, Mr. Chang, looking into the chart, right, just now you did mention if you have written a will, okay, your executor will have to get a lawyer to assist to apply the grant of probate. Yeah. What happened? The list of assets, yeah, okay, you see, when we submit to apply for the grant of probate, basically there are lists of assets to submit to the court. This asset belongs to this Mr. A, right? What happened if they miss out to submit asset? One of the asset or two of the asset they actually miss out after submitting to the High Court when they apply for this grant of probate application. What will happen then?
In this situation, you need to reapply again. Reapply the whole process, GP again. Let me share with you a case that I handled many years ago. I had a customer staying in Taman Muda in Cheras, and when I wrote a will for him, he tell me that whatever the 2 houses I have will give to my wife, and if my wife not around, just give to my 2 adult children, 2 girls. Okay, it's a very simple will. Uncle is about 60 something. Okay, so what happened here is after a few years, because he got sickness, so he passed away, and the wife approached me, and I recommend our miss him to our lawyer, friendly lawyer, to apply the document called grant of probate. Within 3 months, 3.5 months, in fact, everything is done. You know, the 2 property have been submitted to the land office. The land office will do the transfer once you put in the application, the MOT. And all the money in the bank have been transferred to the wife. Okay, so settled. However, after 1 year later, suddenly they saw a letter at the envelope and the letter box at the gate there. And the letter box, the letter say what, is from the developer of Pantan Tun Hussein On, saying that this uncle has another 10% of the final payment of a house that is not paid for the last 6 months. The whole family was shocked. How come the uncle has another house and nobody knows? Then later check, realized that the uncle got a mistress. Okay, So he bought a house for this mistress and he paid by cash. Every installment due 10%, he paid, 15%, he paid. But the last payment was not be done because he passed away. So the developer should be sending a lot of letter to the other address, the mistress house, I suppose. And the mistress can't do anything to it because firstly, the mistress is not one of the legal beneficiary under the law. And look at it, it should be the family that will get it. So once we know that, and we will get the document from the Pandatun Hussein developer, we reapply the whole thing. And when we reapply this time, the GP will still consist of the earlier property that mentioned, add in this new property. So that's why when some what you call that asset that is left out, no choice, you cannot just say apply another document or just this portion, cannot. You have to apply all over again. Grant of probate will be issued only once, cannot be issued several documents, several times. So every time there's only have one grant of probate and all the asset must be still there. So in case one miss out or two miss out, the executor need to reapply the whole thing. That is why in Rock Will, when you do a will, Rock Will, we are actually customer are giving what they call that booklet, the personal asset inventory booklet, where the customer should update the information so that your executor will not need to treasure hunt the asset. Okay, so that all the asset will be complete, and just do one application will do. No need to have a subsequent application. Oh, Karen.
Thanks, Mr. Cheong, for the explanation. Ladies and gentlemen, very important that we need to write our will because the will contain our asset, our hard-earned money, but most importantly, okay, is your wishes during your lifetime. Who will be entitled to receive what asset? So in this situation, yeah, he has another mistress. The whole family must get a shock. It could be how many years already?
Yes,
I think the wife have been cursing and crying like shit. I'm so sorry to say this because end of the day, so we have to look into the situation. Let's say the property is still under his name. Yeah, it's still under his name. I'm so sorry, the mistress get nothing. Unless he bought the property under the mistress name. Okay, that will be a slightly different because it belongs to the mistress. Is the mistress or the developer? In this case, sent to the house, it could be very likely it belongs to this uncle. Am I right to say this, Mr. Cheong?
Yeah, basically there are two things here. Uncle should have approached me. You should do a declaration of trust for him. Then you will single out those assets and give it to her. But then since uncle passed away, he need to settle the 10% in order to get the property. Okay, because it will be singled out if it is stated in the declaration of trust. But since there's no declaration of trust written, set up, so everything will fall under his estate when he passed away. So it forms part and parcel of his estate, and this mistress has no proviso under the Distribution Act, and also don't have the will. The will written already, but no mistress name there. See, so that's why estate planning knowledge is very important if you have mistresses or whatever. Okay.
So, ladies and gentlemen, writing a will, okay, it's very crucial because you can give your asset to your loved one. You know how to protect your asset, okay? By using a testamentary trust in your will, you can prolong your asset to be giving out stages to your loved one, to your children. Even when your children already grown up, whether they know how to treasure the money that you actually have made all the ton of asset in your lifetime. Straight away give to them, is there a better choice? Or you want to have it to be stages by stages? Yeah. Again, very crucial thing is when you write you do up your estate planning, please open to your estate planner. In this case, our uncle, if in the first place that he already declare or actually you tell everything to our Mr. Cheong will know how to protect, guide you along how to do your estate. Because many a time, if you don't tell us what to do, you don't tell us your situation, we won't be able to plan a proper estate plan for you. Yeah, it's not a proper way. So in this case, if you have earlier on had already informed to Mr. Chong, hi, Mr. Chong, I have another issue. I have another small family out there. Of course, we can't blame a person whether you have how many family out there. Our intention is be responsible. You need to take care of your loved one. Yeah, your family, be it your second, third, fourth family. Because end of the day, if you don't do it right, the family disharmony is always there. When a person pass out, I'm so sorry, the rest of your second, third, fourth family will not be taken care. Yeah, there are a lot of estate planning tools that we can actually help to protect your asset. Like it or not, you have to be open for the discussion. And just now also we mentioned, why if you miss out something, the whole process of grant or probate application, we have to redo again. The High Court will not grant you second grant or probate. No two, yeah, it's only one. Therefore, the reapplication, we resubmit, will take longer time. At the same time, will cost you more. Yeah, will cost you more. We will delay the whole process. That's why a lot of people say, why even I have written my will, it takes 2-3 years. First of all, the application, if it's complete, then it shorten your time. But if you have too much asset, unidentified asset, then your executor, the lawyer apply for it, all those things you have to submit very clear. Because I suppose, even you have get your name, your children or your spouses to be the executor in your will, your executor know nothing about your asset until you pass on. And they will rely what you have written on the will. Again, they will search high and low to look for whatever document that you have. Yeah. Bear in mind, Malaysia already have 90 billion asset unclaimed. Ladies and gentlemen, do you want to be the unclaimed money contributor or not? Ask your customer. Malaysia is filthy rich of unclaimed. But why you need to contribute to unclaimed? Do something about that. If you have friends that have not written their will, please invite them to join our session, enhance their knowledge, okay? By knowing how, what, end of the day, we can actually assist you. So ladies and gentlemen, do you have anything to ask Mr. Chong today? Any other question that you'd like to pose? Else, we actually end our session for today. We will continue next week. Once again, Mr. Chong, thanks for your time.
Thank you.
Thanks for your explanation on the Distribution Act. Ladies and gentlemen, we will continue our session. Yeah, weekly, English, Mandarin, English, Mandarin. Today we are having English session. Next week we have Mandarin session. Ongoing, we actually do it right, enhance our knowledge. We learn together, we grow together. Thank you, everyone. See you again. Bye.
Bye. Bye.
Bye.